Hello and welcome. Today, our guest is Brian Carney, an attorney, former prosecutor, and the mastermind behind Win Interactive Incorporated. Today, Brian helps litigators master demonstrative evidence and 3D scene recreation using groundbreaking software he developed himself. Brian, welcome to the Growth Switch.
Thanks, Alex. I'm glad to be here.
Really good to have you. Take us to the beginning of your career. Before you started putting this new software together by yourself, how did your career in law start?
So I started as a Superior Court law clerk working for judges, and then I worked 11 years in the DA's office, and I was prosecuting cases. I was in the gang unit. I was in the appellate division, bouncing around the DA's office, and I eventually ended up trying a bunch of cases, but realizing I wasn't doing anything visual. On the side, I had a side job of a video business. So on the weekends, I was doing a lot of visual stuff. During the week when I'm trying cases, I was doing nothing visual. And that's kind of how I ended up becoming, a visual consultant to trial lawyers, because I went to my boss at the time and said, I think we really should be doing something visual. And I ended up starting a multimedia department in the Suffolk County DA's office in Boston. That department still exists today, and it's grown, so it's doing really well. And I'm proud of that. And now I left that. I did that for 3 years in the DA's office, and I left that. And 25 years ago, I started my own company called Win Interactive, as you mentioned. And I've worked on cases, civil and criminal cases across the United States for the past 25 years, helping lawyers maximize the impact of their visual presentation of evidence.
When it wasn't a norm to use enough visual material, and then you started incorporating because you had this second business and it gave you an insight into what's possible, what sort of impact did it make for the first cases when you brought that visualization to them? Did it make a lot of difference where everybody involved in the process were surprised by how information was perceived? What did the early days look like?
Yeah, I mean, the early days with judges was a little difficult because I got approval to start the multimedia department and bought all this equipment and got it all ready. And I said, well, I better do it on my own cases before I give it to somebody else because I need to prove that it works. So I started my first case in front of a judge in Boston, and he was like, we don't need this. So my first case where I actually built a multimedia presentation, I was told I couldn't use it in court, which was pretty interesting because that was about to be a fail to tell my bosses, well, the judge didn't let it in. But the truth is, it was actually unbelievably helpful. I built an interactive timeline for that case. And having built that timeline, I actually knew my case way better in my closing argument than I would have without it. So my whole closing argument mentally was the visuals that I had created. So I proved to myself that whether or not this gets into evidence or gets in front of the jury, it's still extremely helpful. And then that became proven over time because I had the sense at the time to identify what was the average conviction rate in the Suffolk County DA's office at the time. I think it was, my memory's a little distant on this, but it was I think it was 76% was their average conviction rate. Might have been a little higher than that. I tracked all the cases that we worked on in the multimedia department, and we ended up with a 94% success rate. So it clearly, in my opinion, was having an impact. And you can make arguments, whether those were a representative, cross-section of the cases. But the truth is, we were doing really well with it, and the trial lawyers were the ones who knew, because they knew it changed the way they presented the evidence.
And like you mentioned before, one of the advantages was also that it helped you to better think about the case. So just in the preparation, it changed the way you approached and how you are looking for the things when you are putting the case together, how you're presenting it, how you think through your arguments. It made a difference in the mental model as well, not just the presentation.
Absolutely. That's probably the most important aspect of creating visuals for your case, is especially if you use kind of the approach that I use, which is a structured approach to looking at evidence. If I work with clients several times, they realize I'm doing the exact same thing in different parts of their cases. So the same kind of pattern of presenting evidence works in all types of cases, and it could be civil, it could be criminal, but it's essentially the same basic patterns. And I have an acronym. It's called SMART. It's space, media, access, relationships, and time. And if you use that as a structure for presenting evidence and you have the right tools, then you actually think through your case much more effectively than you would otherwise. And you and I talked the other day. We have, every lawyer comes to a case with the same kind of background experience that they've had, and they just keep building it. And they get used to a habit of building, this is how I build my case and how I prepare and how I organize. But if you come at it from a visual perspective, you actually have a completely different angle on your evidence. And oftentimes you see things in your evidence that you didn't see just going through the normal process. And it's helpful. So I'll have discussions with clients. They say, well, how did you know to look for that? How did you know? And the answer is I'm visualizing your case. And as I visualize it, I'm seeing gaps. I'm thinking, well, wait a second. If you have this and you have this, why don't you have, the thing in between, B? It's, you have A and C, where's B? So having a visual perspective really changes the way you look at evidence, and oftentimes helps reveal items and aspects of your case that you would not have known.
I know that legal sector at large can be very resistant to new technology and changing some things. What did you see in the adoption rate of once you start putting it into the practice, you saw the difference it made in your own preparation, how you presented the case? Were your colleagues quick to adopt the technology, or did they still have an argument of why they didn't want to be involved and do it differently?
Yeah, it's interesting. They don't actually create arguments. They just ignore you. So what happens is you get different types of people. You get the people who are early adopters who really want to do it. They can't wait because they've been waiting for something like this. They just didn't know how to do it, and they're glad that you're here trying to help them. You have the other side, which is never in their life are they going to use any kind of technology, because they have their own habits of how they try cases, and they've never needed it in the past, and they've seen it fail in other situations. They've seen other people use it poorly. So they're not going to use it. They're against it. And then you have a middle crowd, which is they're open to it, but they really need to have it explained why it's going to matter and how much it's going to impact them. Because I think one of the things people can get concerned on is it's going to take more time. And it actually doesn't take more time. It may take a little bit more upfront time, but it saves time, massive time. It saves trial time, discussion time with witnesses, communicating between team members on your trial team. If you have visuals that explain the entire case and you can talk through these visuals with your trial team, you've saved time. But the upfront kind of getting it all ready, that is going to take some time.
Do you think the rate of adoption might hopefully change for the better in the future? Because with AI having a big impact on the technology, it's more top of mind for more attorneys, for more people in judicial system, in legal profession. So there might be more incentive for them to adopt the technology. Or do you think it's still resistant to change at large?
I think we're going to have those three categories of people always. I think the category of people who are interested in it and might do it is going to grow because of what you just said, which is because of AI, and they're going to be more aware of it. But I don't think that I think lawyers have a tendency to be hesitant on anything. It doesn't matter what it is, not just technology. It's just kind of how they're built, which is they're reserved in terms of making changes. So I think that's always going to be part of this. I do think that, once you use it and once you use it effectively, it changes your approach and it changes your understanding of why it's so important. But until you have, I understand it can be concerning to people like, well, wait, I don't know how to integrate this, and how does it get into evidence, and how does it get in front of the jury, and does the jury get it in the deliberation room after the fact? Or in civil cases, a lot of times it's mediations, like, how much of my presentation do I want to present at a mediation? Well, that's strategic decisions that you have to make. But that doesn't change that you should be visual at some level. And there are certainly times when you have a presentation that is really important and something that should not be shown to the other side until you are doing it live in front of a jury. But I think with technology changing, it's definitely going to increase people's willingness to use the technology. Still, it's just, I've been in business for 25 years. I am shocked at how the technology I used 25 years ago is still actually cutting edge technology. And the stuff I'm doing right now, it blows my own mind. I mean, I can't believe what we're building, how life's changed. I'll give you a quick example. I had a case the other day. I've had a few examples like this past year. So I've been working with AI for the past 2.5 years at least. Okay. And, on a daily basis now. And so my mind is always thinking of AI and always thinking of how it can help me. I was working with some lawyers on a case. They were discussing the visuals that we were presenting. And then they had a side conversation about a contract. They were looking for this contract and some documents that they couldn't find. And one lawyer, the lead lawyer, he's like, it's there. And the other lawyer is like, no, we checked. It's not there. We've checked, 15,000 documents. It's gone. It's not there. And the lead lawyer is like, no, it's there. Go get it. The other lawyers, it's going to be, I don't think it's not there. So he says, look, here's the code. There's a C-113 on this contract. That contract is in those documents. It's got to be there. Find it. So the second lawyer, she's like, okay, we'll have, paralegal look into it. And I interrupted and just said, can I ask you what that is? Like, what exactly are you trying to do? And like, yeah, it's just this one page of 15,000 pages in a document. And I said, well, can I take the documents? And they said yes. They gave me the documents. And then I went that night, and in about 1 hour or less, I built an AI program to both optically read, visually read, and optically character generate text from all the documents, the 15,000 documents, and find that document. And within an hour, I had the document. And I asked the lawyer who was going to assign it to the paralegal the next day. She said that would have taken several days of just trying to hand walk through all those documents, So AI is changing everything, in my opinion. And as lawyers start to understand that it's can be useful in ways that you never would have been able to do and never would have dreamed of before, I think people are going to start to warm up to it.
That's such an interesting example. And those, hours, whether it's a paralegal or somebody more senior in the team doing the work, it has a billable hours associated to it. It is delayed to the service. It is billable hours lost. And to your previous example between the different conviction rates, again, it is potentially a very measurable impact that the technology is having. So it definitely should be taken seriously. But I want to come back very quickly to something else that you said about where to use technology as a part of the presentation, because to your point, you might, whether it's in mediation or sometimes in court, you might not want to present everything. I think there's also interesting category potentially where an attorney can present it visually to the clients just in the preparation as well, to help maybe to understand some nuances of the case and better work on the client side as well. Have you seen that to be the case where just using visualization internally help those client relationships to align on the strategy to make sure that everybody's on the same page?
Absolutely. I encourage all of my clients to build visuals. So in law school, literally we were trained to become non-visual. I often give a presentation where I show a book for a 5-year-old and the book is entirely images, just illustrated book, okay? Then you move to middle school and you have images and text. Then you move to high school and you have less images and more text. Then you move to college, much less images and much more text. And then you go to law school and it's no images and all text. So we've kind of been indoctrinated away from visualization. That matters because lawyers don't, think that way then, okay? I'm losing track, but give me the question again, because that was the basis, the background of it.
The relationship between attorney and client as well, just to align on the strategy.
Preparing, yes. So the bottom line is, if you then create visuals, so because of the training of visuals aren't important, visuals are always thought of as the last thing to do, okay? But if you think of them as the first thing to do, and you prepare your team, and you talk to your, witnesses, and you're showing visuals in whether it's preparing your team or showing them to your witnesses and clients, you are going to make everybody, first of all, on the exact same page, because they now see the story like you see it. So you're showing the story the way you see it, and they all see it that way. And then the jury's going to see it that way as well if you end up at a jury. So the answer is yes, preparing visuals can be unbelievably helpful just to help you understand your case or to help your client understand your case. I'll give you one example. And this is really important because, some witnesses are really challenging. I worked on a case where we had a client and he was really invested in his case. It was a contract dispute and he was really upset. He was viscerally upset about being kind of dismissed by the other side. It was a 30 or 40-year family business with both families operating the same. And then one of the families, the children took over and they actually got rid of this guy out of the operation. They just removed him. And he was really upset about the fact that it had been a 40-year history and he couldn't get over this. And that's important to him, but that's got nothing to do with the contract dispute. Okay. Right. It's a motivation about why they did it, but it had nothing to do with the factual contract dispute. So we realized he needs to get controlled. He needs to have something to help him kind of get off of this topic. So we built a process graphic explaining the entire business process. And it's step by step. It just went through the whole business process from the initial communications and the contract that he has with the different vendors. And then it just went through the entire process. And we showed that to him and said, when you get asked a question, whether it's from us or from the other side on the witness stand at trial, think about this process graphic. That's your answer. Okay. If the answer is not on the process graphic, it's not going to be your answer, because he kept arguing or being upset about how they mistreated him. And the answer is, well, that's got nothing to do with the contract, so let's focus. And his testimony was outstanding. And he did stay focused on that graphic, and his answers were always off of the graphic, and he won his case. And I think had we not done that, it could have impacted the case a lot.
I think that's a amazing nugget of wisdom here as well, applicable to so many areas of law and professional services in general, because oftentimes when somebody comes, whether it's a client coming to a lawyer or really any advisor relationship, clients don't know how to think about the problem. They don't have that system. So their approach to trying to solve it might not be, on the chart, on the system, and it might not be relevant to what they're trying to do. And again, whether attorneys or any professionals, one of the best ways we can do to help is to give them the system how to think about the problem. So everybody can be aligned on what success looks like, what actually requires attention, what is relevant, what is not relevant. And without that visualization, it's impossible to transfer, decades of experience and a very specific knowledge to the client to help them understand how to help them.
And it also interferes with miscommunication. So my team years ago, would get together and we'd talk about a case maybe, and we'd be arguing over certain aspects of it. And then we realized somebody on the team said, wait, draw it out. We do this with clients. Like, why aren't we doing it ourselves? We were arguing over things that we kind of agreed on. We just needed to draw it out to say, oh, that's what you're talking about. Okay, that's what I meant. So if you don't have a drawing of it, you don't have a visualization of it, you lack full communication. It makes for better communication if you have the drawing where you can say, okay, this is what I'm talking about. That's what you're talking about. Either they're the same or they're different. At least we now know, instead of kind of arguing over stuff that you might actually be agreeing on. This also applies to a jury. Why would you ever let a jury or a mediator or an arbitrator imagine the evidence on their own? Why would you lose the opportunity to bungle the opportunity to control that vision? So whenever we present visual evidence in any of the cases we do, we have essentially home court advantage. We now have controlled the field. I worked on a case where the prosecutors, I was on the defense team, and we created an interactive timeline, and the prosecutors were using our timeline. Which is funny because it's like, well, that's our timeline and it benefits us. Okay. That was one case. It is just an advantage that you have. It's my timeline and the other side's now using it. We had another case where we built a spatial presentation. So I said earlier, space, media, access, relationships, and time. Okay. So we built a spatial relationship map, and the other side said, well, we'd like to use it. judges like, okay, they can use it. It was like interactive. You could put things on. You could add stars. You could add other visuals. You could add icons. You could add a photograph. You could do different things with it. Okay, so they're like, we want to use it. We want Mr. Carney to run that for us as well. This was a high-profile criminal homicide case, and the other side started trying to use our system, but they had never used it, and they didn't understand why we built certain things into it and didn't build other things into it. So we knew our system. If we wanted to do something, we just did it. If they wanted to do something, they're like, well, can you do this? It's like, no, I can't do that. We literally couldn't. It wasn't like we weren't not, if we could, we would have. But no, you can't do that. Live in front of the jury, they're asking these things, and they're not looking credible at that stage. They're starting to lose credibility because they look like they don't know what they're doing. And that's only because they're trying to use a system they never used before. So my suggestion would be build your own system and make sure you know how to use it. But it really, that's the answer to that, basically.
So do you think in the future more firms will try to develop something of their own so that they can customize it in a way they know how to work with it? Or do you think there will be, whether it's your solution, whether maybe there are some other players in the market that will basically dominate and be the go-to standard that everybody has to learn?
It's a great question because I really don't know the answer to that, because with AI, anything, is possible right now, in my opinion, any one of those scenarios. But, can AI look, I do not underestimate the power and potential of AI. So anything I say that's going to say it has limitations, it may have them right now. It may not have them down the road. Okay. But the software packages that I've been building in the past year are software packages that I've built over 28 years working on my team. I just did them slower because I had a programmer and we had limited budget. We had to do certain things and not do certain things. Right now, I'm building software packages where I'm like, hey, this is a good idea. And I say, AI, fix that. And it instantly, within a few seconds, changes my software to have that additional function. So just like the case I told you about where I built a software package literally in an hour to find a document, these are the types of things that I think lawyers are not aware of, and I think they ought to become aware of. And they don't have to become the person who does it. You just need somebody in your firm or somebody like me who you can hire and say, here's my problem. Can you build a software package for it? And it can be done really, really fast and really effectively. The systems I'm building are also built over 28 years of experience. So I have competitors who I can tell you right now could not build the stuff I'm building, not because they're not smart people and not because they just don't have the same experience that I have. And so my experience has lent itself to, I can build the packages I'm building really fast, but it's because the thinking has been all worked out over 28 years. I've wanted these things for 28 years. I'm now finally getting them. It's not like I'm trying to figure out what is it that I need. But both situations work. And I guarantee you, lawyers themselves may not know it, but they've wanted things for years that they wish they could do looking at their data or whatever. And I can tell you right now, they can do it probably right now. If they start thinking like a software engineer, they start thinking, what's my real problem? What do I wish I could have, and glean out of that data and then go get it.
I think having that clarity of the problem is always the first step. And programming is definitely an interesting subject because for anybody who started learning it and started dabbling into it, getting that clarity on how to solve the problem is the first benefit, because you cannot program a piece of software if you don't exactly have clarity to what has to happen first, what happens next. And I think there was an excuse that you had to have your own developer at the time. It required resources. But with the tools we have available right now, if the attorney has the clarity on what they're trying to do, they can literally just talk to a chatbot effectively and have a first prototype build, and then they can modify it based on their needs. So I don't think there's a viable excuse for not more, whether it's prosecutors or attorneys, to double and to try to build something that would match their way of working.
That's correct. And the other kind of requirement, in my opinion, is doing it. So 2 years ago, when I started doing it, I had some limited knowledge about certain aspects of programming. I mean, I've got some background in programming, very little, but I have a sense of it. in the last 2 years, I have learned so much by just doing it and repeating to do it, and then finding better ways like atomic saves and different things that I had no idea about, that now I routinely ask my AI, does this app that we just built have atomic saving? And, it's like, I didn't even know that. And I learned it just by osmosis, by building the software. So the more you do it, the more you're going to learn, and the more effective you're going to be at it.
For sure. I read a quote recently in the newsletter that I'm subscribed to that said that everything worth doing is worth doing badly. So sometimes you need to get started. You need to have maybe a bad iteration, but because you will learn, like you said, by trial and error, by osmosis, by trying to figure it out, and it will get eventually to the point where you're happy with it, but you have to start.
Yep. I'm a baseball umpire on the side. I do high school baseball games. It's a blast. I really enjoy it. Okay. But I always talk about fielding ground balls. Like, the only way to become a good shortstop and be able to field ground balls is to have failed to field ground balls. You have to constantly be taking ground balls to become better at it. And the more you take, just like golf, Tiger Woods, the more swings you take, the more effective you're going to be. So that's the concept with this, which is take a bunch of swings, try a bunch of things, try projects that you think, well, let me just try that and see. It doesn't matter whether it works. It just matters that you're getting that experience.
For sure, for sure. Talk to me a little bit about the business behind the company. Once you built the first prototype and you started using it, at the time, how did you go about of selling it and having more people try and growing your customer base from there?
So, I mean, I've done different things over the years. I've written articles. I've written law review articles. I've written LinkedIn posts. I've gone to conferences like the National DA's conference I'm going to be going to. It happens to be in Boston this year, and I'm speaking at it this year on the admissibility of AI evidence. Okay. So I've done speaking engagements nationwide. I've done written articles nationwide. I've done cold email. And that's interesting because that actually works sometimes. You just have to have the right timing, and you have to do enough of it. You send out 500 emails, you get one person coming back at you, and that works into one of the biggest cases of your career. So, I think trying all types of legitimate, marketing approaches. Cold calling, I'm not so good at. I don't like doing it, so I don't really do it a lot. I have done it, but cold emailing is a lot easier to me. And I've done things that that you've talked about, I think that you've done, and it's really a great approach because it does two things. I've built content. We had a thing years ago called War Stories. We went and interviewed clients, or we interviewed anybody on a topic. So if there was some topic, some case that was big that happened in Massachusetts, where I'm from, we'd contact the lawyers and say, hey, you just had this huge case. Can we interview you about it and talk about it? It did two things. It gave us content to send out and attract attention that way because people were interested in those higher profile cases or issues. And it got us to meet people that we wanted to meet that weren't our clients already. During that conversation while we're interviewing them, they're like, and what do you guys do? And that's when you have a great conversation because it's a really soft approach. We're not hard selling anybody. We're just saying, this is what we do, and here's why we're doing this. People were, kind of surprised that we weren't charging for that service. It's like, this service is way more, I would probably not get as many interviews if I was charging for it. So we didn't charge for it. It was a great way to meet people. So I've done all types of marketing, and, the best one to me is clients who have won with you and loved working with you and, tell other people, because that's probably the best, in my opinion, from at least my service business. Now, my software has been sold. I haven't done a lot of marketing on that. We're going to do a lot more marketing on it now because we're going to put out 5 initially and probably 10 eventually software apps that actually work with each other or work on their own. So you can just buy the one app, or you can buy, do other, aspects with them. But we're going to be promoting that a lot more effectively. I think I told you we're going to start a podcast, and that's going to be connected to that. The bottom line is people need to be more visual. They need a structured way of thinking about their evidence, and these apps help you with that structured way. And so to me, whether I should have or shouldn't have focused more on marketing of the software, we're going to start focusing on it now because it's really helpful and it's the right time. I'm 25 years into business and I'm proud of that, but it's always been mostly focused on the services. Now we're going to try to focus more on the software.
Makes a lot of sense. And I think it's such a unique combination as well, because you can be very visual about explaining what you do. And it's one of those things when the right person sees it, they instantly get it and they see examples of it. They can start imagining their own cases, their own, client dialogue that will be improved by this, and they just get better from there.
And one thing, what I have done, which was kind of smart, I just did it, but I kept all my 25-year history of stuff that I've done, and I've put that onto a repository where it's available for clients who want to use it to basically just sift through and see various projects that I've done in the past to help them kind of think about their own cases. So you sift through it, you look at stuff, and you figure out, would any of that apply to what I have?
It comes back to being evidence, whether it's in the evidence in trial or evidence that the product that you created does what it's supposed to do. And I think this is something that legal industry can be better at, because too many firms, they try to be best kept secret and they just trying to work heads down, but they can help more people indirectly by sharing, the cases they've done, how they won it, what difference that made. And also people directly, because the right type of client will find them and come to them and already will know, like, and trust them because they saw their interviews or they saw their, war stories, whatever the case might be. It makes it easier for the right person to approach and do business. So I think having those case studies, having a repository of different things you've done over the years and interviews is amazing. How are you, when you're setting goals, because one of the things you mentioned, you want to market more this year, how are you defining success for you this year? What are the objectives that you want to achieve by the end of the year?
Well, we haven't had that meeting yet with my business client, but the answer is we'd like to get, I know my software impacts cases, and that's kind of the number one thing. Like, unfortunately, I'm not focused always on the financial end of things. I've been always focused on winning. My company's name is Win Interactive. I want people to win. I want them to succeed. I want the right solution. I've got a conscience clause in my contract that lets me out of cases if I don't feel it's right. So it's always been about winning to me. And these apps I've been using for 25 years or so, everybody should be using them. And you talked earlier, like, what's the standard going to be? It ought to be the apps I've made, unless there's somebody else who's got a better set of apps. No problem. If they have, I'd like to see them. But the answer is not visualizing your evidence is not the right way to do it in the age of AI. I also think that, going back to what you said, and I'm not sure I'm answering your question, but I'll try to get back to it. But going back to AI, we live in the age of AI where AI videos get created and AI evidence gets created, and it all makes evidence questionable. Do we know if it's real? Is it a deep fake or is it real? And you have real evidence that gets excluded because they think it's not, or fake evidence that gets admitted and it shouldn't have. So as a lawyer, you have a duty to become visually literate and understand visual evidence and be able to communicate visually. And the ABA has a standard for lawyers, which you have to keep abreast of relevant technology. That is getting harder and harder by the day. I am at the cutting edge, in my opinion, of relevant technology, and I feel so far behind. And the average lawyer isn't anywhere near, the cutting edge. So I think lawyers have to start thinking about, well, what is my real responsibility to my client, and how do I communicate as effectively as I can, and how do I know when the other side's using something visual that's not right? I need to know that stuff. And so I think that's, extremely important. If you want to remind me of your question, I'll see if I can.
No, that's a fantastic tangent. And just to, I guess, close the comment as well. If we think about the early days of AI, I think people forget the term now, but it was very impactful. Generative adversarial network, when you basically had two systems, one trying to come up with a fake video of a fake scenario, and the second system would try to find the spots to say, this is why, that's not a true thing. This is why it's a deep fake. And those systems generate the results millions of times, getting really good that, to the human, it's pretty much impossible to tell the difference if the image generated, for example, of the real person or not. And that race is only going to continue whether, we use it AI for any other work as well. So keeping up with it is definitely something important to do. But my question was basically.
Comment on that, if you don't mind. Because I teach a class, I think I mentioned this to you, in Quinnipiac Law School in Connecticut. And it's only to 12 students a year. I've been doing it for 3 years. The co-teacher who teaches it with me, he's been teaching it for 25 years. I believe it's the only class of its kind in law school in America, okay? And it's on visual persuasion in the law. And we talk to the young students about AI and why, if you don't understand it, if you don't use it, if you're not visually literate in it, you are going to get hurt by it. So it's not that lawyers are going to lose to AI. It's lawyers who know how to use AI are going to beat lawyers who don't. So the relevant technology, staying abreast of it is unbelievably important. And it's like, I think the more we hear about like hallucinations and bad case citations, all that's one side of it. But the other side of it is you really need to look at it as a tool that can help you succeed.
My previous question was in terms of the goals that you've set for 2026, in terms of what success would look like for you. What are some of the objectives that you're working on the business side?
Yeah, I mean, what we want to do is have a consistent, we have not done consistent marketing. We want to have a consistent marketing plan. We want to have a consistent podcast. We want to educate people on the truth about how valuable and how easy it is once you start to learn how to visualize evidence, how it's not that hard to do. And the more you do it, like we talked about, the more you do it, the better you get at it. So a consistent marketing plan, in my opinion, would be extremely helpful. That should turn into generated marketing sales of software and possibly services, because the software essentially leads to services. Option A, we give you the software, you can do it on your own. Option B, we can consult with you. Option C, you can have us do it using our software. So it really is a tiered approach. And the truth is, the more we market the software, I think the more both sides of the business are going to grow, which is the sales of the software will grow and the services will grow just because of making more people aware of it. And we have never, ever in 25 years, unfortunately, done what we're about to do, which is we have a consistent plan scheduled to start in July.
Exciting times ahead for sure.
Yes, it is. Yeah.
Amazing. Brian, if somebody wants to learn more about your company, about the software, maybe see some of the past examples that you've mentioned, where should they go online to learn more?
Yeah, the easiest place is wininteractive.com. It's WIN interactive.com. And from there, you can see some of the software because it's not all up there yet, but it's going to be soon. And you can contact me and I'll get you a link to the repository if you have an interest in that. So wininteractive.com, and I'm b.carney at wininteractive.com.
We will make sure to include links in the show notes as well, so our audience can find it easily. Brian, thank you so much for coming today and sharing your experience. And I hope more people will heed to your advice and start using more visualization in their work.
Thanks. Yeah, thanks, Alex. I really appreciate it. This was great. I appreciate it.
Thank you, Brian.